Welcome back to Socially Distant Lawyer. I'm Mitch Hayes.
And I'm Greg Vinogradsky.
And we know all of our fans have been clamoring for us to come back on the air. So we've been on hiatus for a couple months, for good reason though. We both had children. My family welcomed in Hunter Graham in September, and Greg.
Yeah, I had a baby boy, Noah.
So we're back at it now. We've heard everyone wanting us to come back on the air. And today we're going to be talking about, in our first episode of 2022, bad faith litigation and an act that's currently on Governor Murphy's desk.
That's right. So there is a new law that's awaiting the governor's signature. Essentially deals with bad faith claims in regards to underinsured and uninsured motorists. It basically calls for a first party claimant can file suit against their carrier if the carrier acts in bad faith and does not settle their claim within the policy limit. The kind of tricky thing with this whole thing is if that person that gets their claim denied goes and files suit against, say, the person that hit them or for whatever reason, and there's a big verdict from the jury, they can then actually recover that verdict not from the person that hit them, but from their carrier, as long as they can prove that the carrier unreasonably delayed or denied the claim, which is a whole separate issue altogether as far as what that really means. Could it mean something in the context of other bad faith claims where you look at the totality of the circumstances and all the evidence available to the claims handler and whether they denied the claim or didn't feel it was worth the policy limit? That's something that might be explored later through the court system. But either way, if they're successful, they'll be entitled to not only the actual jury award, and they'll also be responsible for the attorney's fees that they incurred, as well as any expenses. And I have a sneaking suspicion there's going to be other causes of action asserted there for consumer fraud, which will entitle them to treble damages as well.
So this area is evolving. We don't know if the governor is going to sign the bill, if it's going to be changed in some respect, but it just went to his desk the week of January 10th. So we're waiting to see what happens. What are the takeaways? What's the impact of this bill if it potentially gets signed in the form that it currently is? Well, first, unreasonableness hasn't been defined. We don't know what the unreasonable delay is. We don't know what the unreasonable conduct is going to be. That's going to be developed through the common law and the courts as cases develop. The other issue is making sure that carriers who are insuring first-party claims are properly documented in the file, saying why they did what they were doing. So what the actions and why they took certain actions during the course of the claim process to make sure that there's no unreasonableness, to make sure that they have the evidence that could stand up to a court once their actions get challenged. Also, there might be less competitive market in the state of New Jersey. New Jersey already has high enough premiums. With this law, are we going to see carriers stop writing underinsured and uninsured motorist coverage because they're going to be subject to more and costlier actions? That's all to be determined, and we're going to see what happens with Governor Murphy if he signs the bill into law or he makes some edits and sends it back to the House in Assembly.
Thanks for joining us on another episode of The Socially Distant Lawyer. Make sure you check out an article from one of our associates, Sam Rodriguez, regarding this topic, and we'll see you next time.